The Honorable, the Supreme Court.
Thank you all very much. And good morning again. Please be seated. And start the live stream. When you're ready, please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Protect Our Wildlife et al., v. Fish and Wildlife Board et al., case number 25 AP 131. Representing the appellant, Protect Our Wildlife, is Attorney Rachel Seelig. Seated at counsel table with Attorney Seelig is Attorney Megan E. Grove. Representing the appellee, the Fish and Wildlife Board, is Attorney Justin G. Sherman.
Okay, thanks very much. And good morning again, counsel. We'll hear from counsel for the appellant first, of course. Please come on up, and for the benefit of the record, you start by introducing yourself and identify your claim.
Good morning. My name is Rachel Seelig from SRH Law, attorney for the appellants, Protect Our Wildlife, Vermont Wildlife Coalition, Animal Wellness Action, and Center for Humane Economy. May it please the court, to protect the balance and separation of powers between the branches of government, it is essential to give VAPA's burden-shifting provision its plain and full effect. This is a novel case where the amended forbearing species rule was adopted by the agency despite a rare objection from LCAR and promptly challenged in court. The trial court misapplied VAPA, and we ask that you reverse the trial court's decision and declare the challenged portions of the rule invalid. First, VAPA is unambiguous. When, as here, LCAR finalizes an objection to portions of a rule, VAPA requires the agency to affirmatively establish those provisions covered by the objection are wholly lawful. Second, this rule adopts ineffective technology as a means to control hounds, a public trails definition that is so narrow it excludes most.
Seelig, I'm sorry to interrupt you. Let me go back to the rule adoption process. When an objection is raised, your argument is that the burden shifts as to all 7 criteria, not just as the trial court did here, to the extent of the objection, arbitrary and capricious, according to the trial court. Is that correct?
That is correct.
Okay, so I understand your argument that those 7 conditions are really interwoven. You have to get to arbitrary and capricious, you almost have to go through all those 7 criteria to make the judgment that it's not arbitrary and capricious. So the trial court erred here because it did not consider all those 7 criteria in the burden shifting. So my question to you is, if that is, and this is a novel issue for this court, if that is the procedure, does that then become, on a public policy basis, extraordinarily difficult and long to get these rules passed if every single time there's an objection, we have to go through 7 criteria?
So fortunately, LCAR uses its objection very judiciously. It's a rare occurrence where LCAR objects, and the iterative process between LCAR and the agency under Section 842A does not result in an amended rule that satisfies LCAR. So it's not a common thing. I don't think we can expect it to become a common thing. But in addition, even with the burden shift, if a rule really is wholly lawful, then an agency should not have difficulty establishing that each of these criteria are in fact satisfied.
So it's not an exceptionally onerous process?
No, we do not believe it would be an exceptionally onerous process as long as the agency can meet its standard of
Is
proof
that
and its
because of the
burden.
novelty of the issue that LCAR doesn't usually say no?
Yeah, that's why this is a novel issue. LCAR normally approves of a rule because it assesses that it is consistent in its view with what it intended rulemaking to have happen. What's unusual here is that that's not ultimately what happened, even with rule revisions.
Can I ask you a more general question? I think I saw in your brief that there are only 5 other states that have this sort of check that would require an agency to vet its rule with the legislature before it's adopted. Is that right?
So 5 other states have this specific burden shifting provision framework. A number of other states have various versions of a legislative veto. which is not what Vermont opted to adopt in 1981.
So the five do what? That is the same as what we do?
The five do what we do in terms of if their version of LCAR objects to a rule, the burden thereafter shall be on the agency to establish that the rule is wholly lawful. And each state has different lists
Yeah,
of
yeah.
what those items would be.
Right, so, and what do the remainder of the states do that have this sort of provision?
So in both New
There's
Hampshire,
no burden shifting? I'm sorry to keep it.
no, I appreciate that. So in New Hampshire and Iowa that have this burden shifting provision, it has been interpreted as we believe Vermont's plainly requires. In other states where there is no burden shifting provision, there are other ways that legislatures have opted to have a check on the rulemaking process, including a legislative veto effectively of rules, or a process to delay when a rule can become effective in order to create more time.
And is the basis for the objection by the legislature, by the committee, is it always that the rule does not comport with legislative intent in the enabling legislation?
So in section 842B, there are 7 different reasons
Right.
that LCAR could choose
Yeah,
to say, we believe this is not a lawful rule. However, once the objection is finalized and we move to the judiciary, it is ultimately up to the court to ascertain whether the rule is lawful or not. So what LCAR thinks about why the rule is unlawful stops mattering. And really the only question is who bears the burden of proof to establish that the rule is lawful. And the broad language of 842, the requirement that to the extent that the objection covers a rule or part of the rule, the burden shall thereafter be on the agency to establish those portions of the rule are consistent with legislative intent, not arbitrary, within delegated authority, and those other 4 factors. That represents a shift for all of those factors onto the agency, and that's not what happened at the trial court in this case.
And may I ask, you also argue in your papers that the standard of proof here is clear and convincing evidence.
Why?
Where are you getting that?
Sure. So first, we actually believe that even a preponderance of the evidence standard, Apelli has not and cannot meet that burden. I'll get into that in a moment. But the reason that it's clear and convincing evidence is that in the typical situation where LCAR has either approved of or simply not approved or objected to a rule, if that rule is later challenged, the burden of proof, including the standard of proof on the challenger, is clear and convincing evidence. It's been described as clear and convincing evidence, compelling indications of error, clearly erroneous, in order to have a rule determined invalid. So if we are merely to shift the burden onto the agency, as 842 requires, then the same standard of proof is appropriate. Otherwise, we are shifting and lowering the burden of proof, which is not what the legislature directed.
So Attorney Selleck, that's an interesting argument. And just to follow up on Justice Eaton's question, my understanding from this court standard of review is that the clear and convincing evidence standard applies for review of board action decisions because the board has the expertise, so this court will give deference to that expertise. This is not at that level of action yet, just with LCAR and the objection. So your argument is still notwithstanding procedurally where the objection is raised, this court should still use that standard, the higher standard.
Yes, deference is no longer owed to the agency, even in its practice of rulemaking, once there is an LCAR objection. The obligation to establish that the rule satisfies this criteria means that we can't rely on deference or presumptions of validity, but rather the burden of proof requires the burden of production and persuasion to actually produce evidence that these rules are in fact valid, and that evidence is not present here.
Ms. Talek, so a lot of administrative cases, we deal with deference to the agency and how they make its decisions and interpret their own rules. And that's pretty much standard black letter law. This case is different though, is it not?
It is.
And the difference is the fact that it wasn't, that deference is not allowed because of LCAR, or is there additional reasons?
So deference is not, the trial court was correct in concluding that deference is not appropriate once there's been an LCAR objection. And that ruling was not cross-appealed, and that should remain in place. But the reason that deference is not appropriate here, I think, is multiple. One is that affirmative obligation to establish the rule is valid. The second is that by filing an objection, the legislature has indicated that even though it delegated rulemaking authority, it was not satisfied with how that authority was used. And that's typically the fundamental basis for why we would delegate for rulemaking purposes to an agency, is that the legislature granted them that opportunity. Once the legislature says, we think you did this wrong, it no longer makes any sense to give deference to an agency in how it proceeded.
Can you give me some better idea than I've got in my own mind about what the implication, if we were to agree with you, let me say it this way, I had no idea about hounding coyotes.
Mhm.
I've never heard of that. I had no idea that such a thing existed. And not completely surprised. And of course, trapping is something else that is, but that is, I think, quite frequent in our state. But what I'm trying to figure out is, what are the implications? If we were to agree with you, what would be the implications beyond this particular case itself? Can you give me some visibility about that?
So within this case, the implication would be that these rules should be invalidated. But
Right.
beyond that, we can expect that LCAR would continue to be very cautious in when it actually files a formal objection, because most of the time, the iterative process under 842A between LCAR and the promulgating agency does result in a rule that LCAR is satisfied with. In those rare circumstances where the same thing happens as happened here, the trial court would then review the rule effectively de novo, not presuming the rule to be valid or invalid, and make its own assessment as to whether the rule satisfies legislative intent, is not arbitrary, is within delegated
Well,
authority.
doesn't this become sort of a separation of powers issue then?
That's exactly why we have to give the burden shifting provision its full effect, because the legislature delegates rulemaking authority. If that authority is not used correctly, that removes deference. And then ultimately, it is the judiciary's obligation to determine if a rule is lawful, if it complies with the statute. And so this protects that separation of powers.
In follow-up to the chief's question, and you may have answered this as part of it, what is the mandate that you're looking for here? If we agree with you, what are the next steps here?
Sure. So the mandate would be a declaratory order that these portions of the rule, sections 3.6, 420, 314, and 415, are invalid and have no legal effect. And that the rules adopted subject to Act 165 were not consistent with that act, and the moratorium was not properly lifted. So I'll turn to the rules themselves at this point, if I can. The trial court did not demand evidence that radio frequency callers for recall were consistent with Act 165's intent to develop reasonable and effective means to recall hounds. It was not mentioned when the rule was filed with ICAR to begin the rulemaking process. It was not just included in the description of the intent of Act 165 in the agency's responsiveness summary to voluminous public comment. Throughout the 842A process with LCAR, the agency defended the rule as being consistent with the intent to reduce conflicts between landowners and hounders, but at no point argued or produced any evidence that the rule was consistent with this other express intent of Act 165.
Ms. Allen, I apologize for this question, and it's not a rhetorical question, but who's getting protected here? Is it the coyotes? Is it the hikers? Is it the people in the community? I mean, what is the request? And again, I don't mean to have a bad question like that, but just a curiosity that
Yeah,
on this type of situation.
it protects landowners, individuals who are out on their own land, domestic animals. The record has many examples of hounds harassing, attacking humans and their animals, horses, dogs, and other animals. When these hounds are released to run in packs at high speeds pursuing coyote, they come onto land, they get distracted, they attack people and animals. And so the idea here is we need to have effective control of these dogs to prevent those horribly traumatic events from continuing to occur. The control definition adopted in the rule relies entirely on the training collar to effect recall. There are other provisions that allow for tracking and theoretically for identification, but it is only the collar that is put forth as allowing for recall of the dog, which we all agree is the core element of when there is control over these. The problem is that these collars are defined in Rule 319 as relying on radio frequency technology. And the record is very clear that technology stops working when the dogs are more than a mile away, even in ideal conditions, from the handler, which happens frequently in hounding.
And in fact, the handlers have to use their vehicles
They do,
to be
yes.
able to, yeah.
And the radio frequencies are also interrupted when an animal crests a hill or mountain or moves through deep forest because that interferes with the signal. So the agency did not have the authority to choose a means that was ineffective in order to control hounds. I see my time has expired. If I may briefly conclude,
Please.
BAPA requires a full shift of the burden of proof onto the appellees in order to establish that their rule is valid. These rules adopt ineffective technology, a definition of public trails which is far too narrow to be consistent with Act 159's intent to protect public recreators, and then further carve out traps that are set in only a couple inches of water and therefore have no less risk to the public if they are just inches from a trail. So we ask that you determine these rules to be invalid and remand for further rulemaking and reinstate the moratorium on hounding until that is complete.
Thank you very much.
Thank you.
Your time has expired. We'll hear from counsel for the appellee, please. Come on up. And again, for the record, if you would start by introducing yourself and your client.
Of course, Your Honor. Morning. May it please the court. My name is Justin Sherman from the Vermont Attorney General's Office on behalf of the defendants' appellees.
Thank you.
After an extensive rulemaking process, one that spanned at least a year, and at the direction of the legislature, Fish and Wildlife adopted the fur-bearing species rule. The trial court rejected appellant's arguments that the rule was contrary to legislative intent and was arbitrary, and it upheld the rules as being valid.
Can you give us a thumbnail sketch of what the rulemaking process is that your client engaged in?
Yes, Your Honor. It spanned from approximately June of 2022 through December of 2023. As we've submitted the administrative record with the court, it spans approximately 20,000 pages, at least, if not more. As part of that process, Fish and Wildlife held hearings, convened meetings, studied data, looked at evidence, and I think that it was relatively extensive rulemaking process.
But then you have the LCAR issue.
Pardon me, Your Honor?
Then you have the LCAR issue.
And we have the LCAR issue, which was included as part of that process. So at its core, this case is an Administrative Procedure Act case, and it does present a couple of novel issues for the court. I want to start by addressing those. The first is the scope of the burden shift that accompanies any LCAR objection, and the second is the effect that the LCAR objection has. First, on the scope, our position is that the LCAR objection only shifts the burden to the state on the narrow basis of the LCAR exception and not on all 7 statutorily enumerated factors in 842. As a starting point, the plain language of the statute itself limits the burden shift only to the stated basis of the objection. And Your Honors have talked about this language before, to the extent that the objection, we believe, limits the burden shift. The extent of the objection in this case is on legislative intent. It doesn't touch any of the other 6 factors. Additionally, the statute as a whole, yes, Your Honor.
So Attorney Sherman, let me ask you that question. I know that the appellants objected on the legislative intent, but to show legislative intent, don't you necessarily have to go through those 7 factors to show that the process satisfied those factors that will be used to determine whether a rule is arbitrary and capricious?
I don't think you do, Your Honor. I think there are some
Yeah,
factors
so
like,
tell me why, because that's interesting to me.
yeah, so there's things like the economic analysis that I don't think necessarily weighs into whether a rule is arbitrary or whether there's some sort of reasonable basis in the administrative record for it. But turning back to the statute of the whole, as a whole, and courts in interpreting statutes look at its overall purpose and it as a whole to determine its application. And here, the statute contemplates an iterative process between LCAR and an agency. Before lodging an objection with the Secretary of State, LCAR has the right to give the agency notice of any objections. Upon receiving it, an agency can review it, they can respond in writing, and they can include revisions that, I quote, seek to cure defects noted by the committee. For this process to work, LCAR must give an agency notice of its objection and its grounds for its objection so that an agency has a meaningful opportunity to cure any defects. And here, permitting a single LCAR objection on one point, in this case on legislative intent, but then shifting the burden on all 7 statutorily enumerated factors would undercut this iterative process because it would deprive the agency of the required notice and the meaningful opportunity that it should be afforded in order to cure any defect. And I think as a matter of just practical sense, it doesn't make sense to shift on all 7 factors. Justice Waples asked my colleague if she thought it would be overly burdensome. And I think that, yes, it would, in our view. For an agency to receive a pre-suit LCAR objection on only one ground and face a proverbial molehill, only to later then be sued by someone and face a burden shift on all 7 statutorily enumerated grounds, the proverbial mountain would, when they didn't have an opportunity to notice about what was the problem or given an opportunity to cure it.
But aren't you excerpting, I think that's the term, out part of the plain text? And doesn't that run contrary to our interpretation of statutes that we should not excerpt a phrase without considering the provision as a whole?
To the extent of the objection
Yes.
language?
Yeah.
Yes, Your Honor. I mean, we submit that I do think that the extent of the objection cabins the shift to just the one factor, and that in considering it in tandem with the overall purpose of the statute, that our reading should carry the day.
But doesn't that run counter, though, to statutory interpretation? To excerpt a phrase without considering the provision as a whole?
The statute as a whole, I think you can still accept our interpretation of to the extent of the objection language while giving the rest of that provision its effect. Now turning to the second novel issue, which is the meaning of the burden shift and its effect on deference. Our position is that the agency is still entitled to deference even with the burden shift. Put simply, 842 shifts the burden, but it doesn't change the burden.
Doesn't deference require that there be information that the agency did the job correctly?
Could you say it one more time?
I'm
Your Honor?
sorry,
I'm sorry.
doesn't deference, my microphone's over here. Doesn't deference require that there be a determination that the agency did its job correctly in order for it to get deference?
I think that agencies are generally afforded deference, Your Honor, and I think that we get there even under our position in this case. So there's no language in the statute at all that the burden shift removes deference. What the statute does provide, however, is that the fact of an objection shall not be admissible evidence in any proceeding other than to establish the facts of the objection. This is to say, an objection cannot be used to show either the validity or the invalidity of a rule. And if the court were to permit an objection to remove deference, it would change the burden and it would afford an LCAR objection certain weight under the statute that is expressly disallowed. As a matter of practice and what this looks like, with the burden shift, it does remove the presumption of validity. Normally, an agency facing a challenge can rest on its laurels, and a challenger is being forced to come forward to point to information in the administrative record that the rule is invalid. But here, with the burden shift, that's no longer the case. An agency is now required to go first, to come forward and point to information in the administrative record showing the validity of the rule. Try to put this simply, what it means is an LCAR objection says to an agency, establish it. Establish its validity first. We think that affording an agency deference, even with the burden shift, strikes the appropriate balance between the responsibilities of LCAR on the one hand and an agency on the other.
But it's such a rare occurrence that LCAR doesn't approve a rule. It's not something that happens on, it's never happened that for any of us. So it's not something that occurs on a regular basis that needs to be concerned. Because most of the time, they do their investigation and they approve the rule and it goes forward. So
Sorry, go ahead, Your Honor.
no, I just, it's not like it's going to create a lot more work and litigation for state agencies because the situation is very rarely utilized.
It is, Your Honor. I don't dispute that at all. It is a rare occurrence, and even in other states that have similar provisions, it doesn't come up all that often. However, I don't think that affording LCAR some sort of veto power is consistent with the law, because under the statute, the effect of the objection is that it shifts the burden, but it cannot be used as evidence for anything other than the facts of the objection. So I don't think we can read into an objection that it affords any weight or afford any weight to the objection one way or the other.
The objection itself.
To the objection itself. Yes, Your Honor. And in terms of striking the appropriate balance, I do think that LCAR with an objection still has a role. Under the statute, LCAR affords a certain subset of the legislature to come forward. It gives them an opportunity to voice concerns, to express disagreements with the proposed rule. But affording an agency deference, on the other hand, still allows them the chance to operate in their area of expertise, to utilize their specialized knowledge, which the legislature itself as a whole tasks them with doing.
How do you view the appellant's, your opponent's position with respect to clear and convincing evidence? Does that tie into this part of your argument?
We disagree. We do not believe that clear and convincing evidence is the appropriate standard as it pertains to arbitrariness, for instance. We believe that the standard is whether there's a reasonable basis in the record for it. Clear and
Not a preponderance of the evidence, a reasonable basis in the record.
Yes, Your Honor, we're in a strange sort of administrative procedure land here. But in terms of clear and convincing, I think that would be a departure from Vermont law. Under most circumstances, clear and convincing evidence is used in well-established areas like fraud, for instance, or where clear and convincing evidence is specifically imposed by the language of a statute itself to increase the burden. And as we talked about, we do not believe that the burden shift in any way changes the standard. It just shifts it. So,
Why is it not a preponderance of the evidence? Because that is the standard the court uses when, I mean, I think I originally said it's the deference is clear and convincing if we're dealing with a board and their expertise. But why is it not preponderance of the evidence? Is there a difference with reasonable basis in the record and preponderance?
I'm not sure there's a huge difference, Your Honor. Can't.
That's why I asked you.
Yeah,
Not
I
there.
don't think there's a huge difference. I do think a reasonable basis in the record, again, with the burden shift, an agency does have to come forward to point to information in the record to establish the validity of the rule. So that's our position on that. I want to briefly touch on an issue that the appellants raised in their brief about whether the state needed to file an appeal. We submit that we do not need to file a cross appeal in this case under the court's recent decision in State versus Roberts. In that case, where a party is content with the final order of the trial court, they do not need to raise alternative arguments, especially where the alternative arguments would result in the same outcome, the same procedural outcome of the trial court. And here, there was no need for us, for appellees, to cross appeal because the state was content with the final order, which was upholding the rule as valid. And that deference was an alternative argument that would not have resulted, or that would have resulted in the same outcome because the trial court refused to extend deference to the agency. It still upheld the rule as valid because it was contrary to, consistent with legislative intent and not arbitrary. Now, if I could turn quickly to the rules themselves. The definition of control, this comes in with the coyote hunting.
That's under Act 165 you're referring to, correct?
165, Your Honor, yes.
And you are, in my mind, synonymously using the term reduce and minimize. Is that what you're doing?
Yes, Your Honor, I think
Why? They're different words.
the reduce,
From when I read the statute, it has a different implication.
we think that the best reading is for them to be the same, Your Honor.
I'm sorry?
We submit that the best reading of minimize in this case would be the same as reduce. So the intent of the statute is to reduce these harmful interactions that we've talked about. But reduce doesn't mean eliminate entirely. It doesn't mean abolish. It doesn't mean terminate. It means to diminish. The word minimize shows up later in the statute. The legislature did not say, as appellants argue, that it should be limited to the minimized to the maximum extent possible. The legislature in the past, when it has intended something to be done to the maximum extent possible, has expressly stated so. And that is absent in this case. And as the trial court recognized, it makes little sense to reduce conflicts, the general intent of the statute, only to later minimize them even further based on one word. Minimize itself incorporates the term harass in it. And the term harass is defined to annoy a person or domestic animal to such an extent as to significantly disrupt normal behavioral patterns. And the correct conclusion that the trial court gave was that it wasn't required to remove all risks. It wasn't intended to minimize to the maximum extent possible. Backing up to legislative intent, the purpose of this statute, and for the first time, I might add, coyote hunting was regulated in Vermont as part of this rule and this law. The law permits the activity itself. So to be consistent with that intent, hound hunting must be allowed. Simultaneously, the law sought to reduce conflicts. I see that my time is up.
Your,
As I've announced. to the entire
your
room, I'm
watch is
sorry.
in harmony with our watch, I'm glad to see.
Otherwise, we will rest on our brief and thank you to the court for its time and consideration.
Thank you very
Thank you.
much. Does the appellant have any time?
Appellant has no time remaining.
All right, please call a conclusion of the hearing.
That concludes today's